It's 2 o'clock, and the Code Board of the City of Tarpon Springs is now in session. Bobby, would you call the roll, please?
Yes, ma'am. Ms. Wade?
Present.
Mr. Perfidio?
Here.
Mr. Weeks?
Here.
Mrs. Telliar is absent and excused. Mrs. Archer? Here. Mr. Rollinston?
Here.
Dr. Matea?
Here.
And Mr. Ogle.
Here.
That completes your roll call today.
I'm missing one thing, the procedures page. What number? Procedures page? And we didn't get those.
No, she took them. They're supposed to be, I thought,
Are they back here somewhere? Okay, we'll come back to it. If everybody would please stand, we have an invocation and a pledge. Our Heavenly Father, we seek blessings on the task before us. Bless our efforts with clear insight, our deliberations with wisdom, our work with clarity and accuracy, and our decisions with impartiality. We pray that our work this afternoon will find favor in your sight. Amen.
Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. It was in the red, in our folders. No, but I didn't have a folder this time. No, no problem. I thought she had put them in the back.
I apologize for that.
I can do the regular quasi-judicial one if you'd like me to do that.
I apologize for that.
We changed to having it in the book, but that's not
Here's your
in our
hearing
book.
procedures. Here's this one here.
It is the, of this board to, and then read how the process works through question, answer, that page.
I have the general quasi-judicial one that I can read, which is, might be similar to what
Alrighty. The attorney that represents the board, Ms. Kardash, is going to read the procedures for how the process works.
Good afternoon, everyone. The matters before the City of Tarpon Springs Code Enforcement Board are quasi-judicial in nature. In a quasi-judicial proceeding, the board's function is to make findings of fact based upon the evidence presented at the hearing and apply those findings of fact to previously established criteria contained in the City of Tarpon Springs Code of Ordinances. This is a legal decision regarding the application before the board. The board may only consider evidence that the law considers competent, substantial, and relevant to the issues arising from the application and the applicable code sections. Any and all persons providing testimony at this hearing are required to do so under oath. All persons testifying at this hearing must give their name, address, and must indicate whether or not they have been sworn for the record prior to proceeding with their testimony. All testimony and questioning at this hearing must address the matters that are relevant and material to the issues under consideration based on the established City of Tarpon Springs Code of Ordinances. If any board member has disclosures regarding an application, please make your disclosures on the record at the beginning of the hearing, which would include ex parte communications and any voting conflicts of interest. If there is not a full board present, the applicant may request a continuation to the next regularly scheduled meeting. I'm sorry, I don't know if that's applicable to this board. This is from another board.
I'll try to sum up with, we're going to swear people in that are going to testify, and then when it's your turn, the city will give their testimony, and you'll have a chance to ask a question of them. Then that's followed by your giving your testimony, and they can ask questions of you. Then there'll be a summation, and the board will make their decision. At this time, if you're planning on testifying, we need to swear you in. Please stand and raise your right hand.
Do you swear the testimony you're about to give is whole truth and nothing but the truth?
I do.
I do. Thank you. Be seated.
If you have a cell phone with you, please turn it off. We are a couple of changes on the agenda today, just because of the folks that have come. And item number 4 will be heard as item number 1. And that case is case number 23-800000038. Okay, bear with me, Nomiko Kuskudis.
Yes,
And
yes.
Tina Kuskudis.
Yes.
And George Kuskudis and
Yes.
Maria Kuskudis.
Yes.
It's a parcel, and then the empty parcel of land.
Also, as a companion, and because it all is affected by the same case, would be Mr. Lindiakis, who's also
Madam
present.
Chairman,
I can't hear him, can you? Would you
Okay.
pull the mic
Oh,
closer
yeah,
and turn it up just a little bit? Thank you.
Madam Chairman, can you hear me?
I need you to identify
Okay,
yourself.
I'm sorry. My name is Michael Kuskudis. My office is 623 East Tarpon Avenue. I'm also the owner of the property that is subject of this case.
Thank you, that's all we need at this
Well,
time.
I was,
And your relationship to this case?
well, I'm the owner of the property.
Owner of the property.
As well as I represent Mr. Lindiakis, who is on your, because it's all relative to the same facts as the code enforcement officer would attest.
Counselor?
Okay, we
Okay,
will give,
before
we're
we
going to let her give her testimony,
Well,
and then we can answer to that.
But I'm trying to make them a companion case, ma'am, is what I'm trying to do.
All right. So here's, I understand what you're trying to do, so can we just hold on for 1 second? Before we move farther with this case, I believe that we have a disclosure for the record.
Thank you.
I would like to recuse myself from this case since Mr. Kuskudis is my personal family attorney.
Thank you.
I would like to recuse myself from this. One, Mr. Kuskudis is my attorney, family attorney, but another part of his family is also, I contract with him under their association, so I'm a contractor with them
All righty, thank you.
as an employee.
We still are left with
One.
a sufficient number of board members to hear the case.
Okay. So,
The city will present their part.
may I just
To
resume?
the extent that you have items that are relevant on both this case and the next case, or whichever, I'm sorry.
There
Gina-
could be, the one following, which is.
One following it?
Which is 5 on your agenda.
Okay, so number 5, which is 23-8000037, to the extent that you have evidence that is applicable and presentable on both, what I would request that you would do is identify that as you are presenting the evidence, and then when we move on to the next case, then request the board to consider that evidence under the next case as we present that. And with that, I would ask, Madam Chair, since the cases are related, that we do hear 4 and then 5, if there's no objection from the city on that.
No, ma'am.
Okay.
So we're going to complete 4.
We'll complete 4, and you will identify for the record the evidence and testimony that you wish to be considered under both cases.
Yes, ma'am.
Okay, thank you.
That works for you? Thank you.
So in that binder right there, if you flip to tab 4, you can follow along, all the information is in there.
Okay, thank you.
And Cindy, pull your mic up a little too. Thank you.
This is not a homesteaded property. On February 24th, 2023, I inspected the property located at parcel number 12-27-15-15-26-4-000-0280 due to a citizen complaint. This is a vacant residential parcel that is overgrown with grass, weeds, and vegetation in excess of 12 inches in height. There's also vehicles and trailers being stored on the property that are not allowable. There are 2 work trucks, a commercial enclosed vehicle, a boat on a trailer, 2 commercial dump trailers, a smaller trailer, and an empty boat trailer. The commercial enclosed vehicle has an expired tag from 2006, and the rest of the vehicles and trailers do not appear to have been moved regularly as the grass is growing up around them. The property was posted with a notice of violation with a compliance date of March 13th, 2023, a copy mailed to the property owner via certified mail, and posted at Tarpon Springs City Hall. A reinspection was completed on March 13th and March 29th and found that no efforts had been taken to bring the property into compliance. Due to noncompliance, the property was referred to the Code Enforcement Board. Compliance can only be achieved by removing all vehicles and trailers being stored on the property and mowing and maintaining all grass, weeds, and other vegetation below 12 inches in height at all times. It should be noted there are multiple prior cases on this property for the same violations. A hearing notice was posted on the property on March 29th, 2023, a copy mailed to the property owner via certified mail, and posted at Tarpon Springs City Hall. The division recommends giving the respondent until April 27th, 2023 to achieve compliance. If compliance is not achieved, staff recommends the Code Enforcement Board impose a fine of $75 per day beginning on April 28th, 2023 until the property is brought into compliance. Exhibit 2 is going to be the photographs of the property taken on February 24th. You can see the trailers, the boat, the trucks, and the overgrowth. Exhibit 3 is going to be the notice of violation, along with the certified mail receipt and affidavit of posting, the notice of hearing, certified mail receipt, and affidavit of posting. Exhibit 4 is going to be the property appraiser as well as the tax collector. And for follow-up, after I had sent out the notice of hearing, I did have contact from this gentleman who did request an extension. Due to everything already being set on the agenda, I told him that we could give him more time. The vehicles that are on the property actually belong to the neighbor, which is the other case that he's speaking of, who has been very ill and has not had ample time to get the vehicles off. They have been there for a very long time, but since the notice went out, he didn't get it and he wasn't able to remove them. So the city does not have an issue at this time granting more of an extension than the 27th, if the board sees fit.
You finished? Do you have questions for her this time? Just
Actually,
questions, and then you
I-
can present your case after that.
Actually, I do. We talked the other day on the phone, and I asked you if there, can you name the complainant? And you said that you were driving by and you noticed the violations.
Is this a question?
Yeah, so
Okay.
just bear with me. I'll ask the questions. And today, your testimony was that you received a complaint. Can you give me the name of the complainant?
It was actually myself who drove by. It's just an error. I had a complaint down the street, and as I was traveling back is when I made this one.
Okay.
So this was actually myself.
Okay. So you're the complainant?
Correct.
So then the question is, and just for my clarification, is the city, it was my understanding that code enforcement was called upon complainant's request. So just moving forward, is the city becoming more proactive in its enforcement of the codes?
We can be proactive, yes.
Okay. Okay. You also testified that there were prior violations on this property. Can you cite those? Which property, what were the prior violations? I've owned this property for several years, and I don't recall ever having received or ever being cited for a violation.
I do not have them listed. I can look them up if you'd like.
Okay, but your testimony was there were prior violations.
Yes, sir.
So that you can't provide that. And the reason I'm going this is because my concern is, I know how the board looks at repeat violators, and I think it's incumbent, and I am going to ask for an extension, but it's incumbent that if that ever is an issue, just the terminology that a prior violator is not really evidence per se because of not being able to provide the information on dates or times or prior violations, because a violation could be something other than any of these violations. Would that be a fair
The
statement?
city's not seeking a repeat violation,
Okay.
and that was just some history background.
Okay, because I've only owned the property for a certain period of time. If there were violations prior to my ownership,
No problem.
I don't want this board to suspect or be of the notion that we ignore the ordinances of the city if that was something that was prior to, because you look at the parcel ID number when you code these things. Is that correct?
Yes, sir.
Okay. So I'm actually, and I spoke with the attorney for the city, as the witness testified, and this is also, and I'm bringing the same testimony or the evidence with regard to the next cited case. Mr. Lindiakis, who is my neighbor on this property, all that property, all that equipment belongs to him. He was getting, at the time of the first notice, he was going through a kidney transplant, and he's been going through dialysis. So his opportunity to correct the violation, even though it's on my property, it's his equipment, and as a neighbor, I was not going to just grab a tow truck and have these things removed. I don't think it would have been fair to him. And so prior to this little while ago, I had asked for an extension, 30 days. I know Mr. Lindiakis has been diligent in trying to get some of this stuff taken care of. The trailers, I think the truck has been plated. The box truck will be removed. The dumpsters, he's got a permit because he's doing some construction on his house, some renovation, so we've provided copies of the permits. So I think the only issue at this point may be the box truck. But, so I'm asking for 30 days to this be deferred, give Mr. Lindiakis the opportunity to have his stuff removed from our property. And I can continue defending this matter, but before we move forward and waste this board's time, I'm asking for a deferment for 30 days.
Would you like to summarize?
Are you okay with a deferment,
Yeah,
or?
we leave that up to the board's discretion, where we understand the extenuating facts that are being presented.
Thank you.
Are you-
Questions from the board or motion?
We're still on the first case, or we're?
We're ruling only on the first case, and that ruling will be repeated on the second case, if I'm understanding.
No, it's not going to be repeated on the second case. That will have.
Total
That's a
separate.
different, yeah. That aspect of it is separate, except for the pieces of evidence that overlap. So the first issue that the board has to resolve is whether or not you're going to grant the deferment for 30 days. He has asked for a deferment, so you have to rule on whether or not you want to defer this first case for 30 days. And then you can decide if you want to move forward with additional
Can we
testimony
find it
and
in
evidence.
violation and give the 30 days as our time frame?
If the court's going to find, if this board's going to find a violation, I'm going to present, I'm going to basically present a defense.
So he has, what he's saying is that he has additional evidence to present to the board regarding the facts and substance of the actual violations. So if you vote no, you're not going to defer it, he has additional testimony to present. It's essentially a pretrial motion.
What would y'all like to? Does anybody want to make a motion to defer or
I'll make-
to rule on this case?
I'll make a motion to defer 23-800000038 for 30 days.
Second.
Roll call, Bobby?
Yes, ma'am. Mr. Rollinston?
Yes.
Ms. Archer? Yes. Mrs. Telliar? I'm sorry, she's absent, apologize. Mr. Weeks?
Yes.
Mr. Perfidio?
Aye.
Ms. Wade?
Yes.
Could we stipulate to the presentation as to the next case as it being the same?
Yes.
That's acceptable.
So before we do that, Madam
Need
Clerk.
to summarize
Yeah.
what we just did.
So this case will be deferred for 30 days until the May 11th, I believe, is the next scheduled Code Enforcement Board hearing.
Correct.
Yes.
Okay. And we can move on to the next case and have just the clerk read it into the record, please.
On your agendas, this is case number 5, case number 23-800000037. Elias Lindiakos Mavel Lindiakos Maria Panisis, 113 West Cedar Street. And then will she present that, or we just accept it? that we-
So before we move into that, are there any ex parte communications? Are there any
This-
voting recusals for this case as well? I know that we had 2 on the last one, so I just wanted to double check.
I will recuse myself for
From this one as well.
the
Yes.
defendant is our, my
Yes.
personal lawyer.
Dr. Mateo? Would you also like to be recused from the second part of his case?
Yes.
Thank you. So noted. And we don't need to present all the same things again? We can just, or do we need to summarize
We'll
it?
have to do another motion on this. I don't know if the city wanted to present its case, so the city does
I'd like
still.
to present our case because the facts are different.
Thank you.
Okay, thanks.
Proceed.
This is a homesteaded property. On February 24th, 2023, I inspected the property located at 113 West Cedar Street due to self-initiated activity. Upon arrival to the property, it appeared that much of the large 2-story house was under construction. The roof was covered in polyglass sheeting, there were no soffits, fascia, or gutters, and a large scaffolding was by the front of the residence. Most of the windows were covered with metal sheeting and were unable to be opened, and the front 2 windows were covered in metallic sheeting. The side of the residence had rotted areas, missing areas that were covered with wood boards, and the protective treatment was peeling off. A large section of the protective treatment on the front of the residence was covered in green algae, with other sections covered in Tyvek sheeting. The upper balcony has sinks, buckets, garbage, and other items piled up, while the downstairs had garbage, construction materials, and tools, a pile of metal tubing, and piles of other debris. There was also a vehicle in the driveway under a car cover on jacks with 2 tires off. There are no active and open permits for any of the work that is currently being done on the residence. A roofing permit was applied for in 2021, however, has since expired, and no further permits have been applied for, approved, or issued. The property was posted with a notice of violation with a compliance date of March 13th, 2023, a copy mailed to the property owner via certified mail, and posted at Tarpon Springs City Hall. A reinspection was completed on March 13th, 2023, and found that no efforts had been taken to bring the property into compliance. Several further inspections were also completed on March 20th and 29th and found the same, and no contact had been made from the property owner. Due to noncompliance, the property was referred to the Code Enforcement Board. Compliance can only be achieved by properly removing all of the junk, trash, debris, and outdoor storage from the property, or storing it in a fully enclosed structure, having all vehicles on the property be in operable condition with valid and current tag and registration, and with the use of a licensed contractor and proper permits, the roof soffit and fascia, protective treatment, windows, and doors are all to be repaired or replaced to building code. All permits are to be applied for, approved, issued, and finalized. The hearing notice was posted on the property on March 29th, 2023. A copy mailed to the property owner via certified mail and posted at Tarpon Springs City Hall. The division recommends giving the respondent until May 11th, 2023 to achieve compliance. If compliance is not achieved, staff recommends the Code Enforcement Board impose a fine of $250 per day, beginning on May 12th, 2023, until the property is brought into compliance. Exhibit 2 are going to be photographs. This first one is of the downstairs area. The next one is going to be of the upstairs front. And then the inoperable vehicle. Several photographs of the side of the residence. Exhibit 3 is going to be the notice of violation, certified mail receipt, and affidavit of posting. There was also a notice of violation that was amended that was also sent out, certified mail. The notice of hearing, the certified mail receipt, the signature card that it was received, and affidavit of posting. And Exhibit 4 is going to be the property appraiser as well as the tax collector. Exhibit 5 is going to be the prior roofing permit that was applied for in 2021 and that was expired. After the notice of hearing went out, I did hear from the property owner, who again stated that he has had some pretty substantial medical issues over the past month and did not receive the notice of violation. He was going to get with his contractors to reapply for the permits. 2 days ago, the permits were reapplied for, the roofing permit was reinstated, and the windows and doors permit was applied for. They still have not been approved or issued or anything like that. And the rest of the property remains the same.
This already has a May 11th date, so I don't think that deferring is a possibility. Does anybody like to make a motion? Do you want to make a comment, sir?
I would like to ask, because, you know, when you look at the evidence that's presented, obviously, if you look at the house is and has been in significant need of repair. I just would like to ask the city if it takes into consideration somebody's financial ability when it comes to making repairs on their house. Is that a consideration, or health issues? Because when you say health issues, he had a transplant, but he's been suffering from health issues for years that has culminated and was allowed him to get a transplant. And that's why work was not done from 2021, is because your health comes first, and then you have to have the ability to make improvements. You know, he applied in 2021 for a permit to get this stuff done. And when you can't afford it, I just don't, my biggest concern, and maybe I'm getting on a soapbox here, is when we look at citing residents and taxpayers of this community, if a house is in disrepair, is it in disrepair because they can't afford it? And then now we are getting them with a heavy hammer on top of it? And I apologize, that's not why I'm here today, but you know, we just have to make sure that with the direction that we're going as a board. That being said, I'd like to ask for the things that are cited for other than the disrepair of the home. We have are the equipment or the stuff that is on our property, which I'm asking the same. I guess it would be 30 days if it's the 11th to get the balance of that material off of our property. So I think you might be correct in not necessarily needing the deferment for that, but I just want to be cautionary to this board when we look at our residents and our taxpayers, and we go to look at their quality of life and how they live. The question should always come up: can they afford?
Yes, sir. I'm going to interrupt you for a minute.
Okay.
We also need to consider the people that live nearby.
I understand that.
And the other
I
residents of
understand that.
Tarpon.
I
so-
understand that, but.
Thank you.
But it's a matter of having heart. Thank you.
Anybody have a question?
Is anyone living in the house right now?
Didn't hear.
Yes, there are.
Your
Boards up on the
summary is
windows.
stated in here, and that's what we should
It's just
use as
homestead,
her
yeah.
summary. Is that what you asked?
It's homesteaded. Someone's
That's what
living-
I asked, if anyone was living there.
Yeah.
Yes, ma'am, there are people living inside.
Does he have family around at all?
He's got a sister and a brother, but they have their own
Pick
lives.
up around, or just, I
Pardon?
know, that could maybe pick up things that aren't,
E-
you know, just
every-
kind of make it look a little bit better.
I will
before-
tell you this: everybody has a different family dynamic, and,
Yes, sir.
and some family dynamics don't bode well with assistance, and I could just leave it at that.
And it's been 3 years.
As there is.
And we don't want anybody living in squander either.
I understand that. But we don't want to step on somebody when they're down either.
Would you
No,
like to
sir.
make a motion?
Of course, we're all living with that right now.
Yeah.
I'd like to make a motion. I move in case number 23-800-0037 to find the respondents, Elias C. Lindiakos, Mavel N. Lindiakos, and Maria A. Parnesis in violation of the City of Tarpon Springs Code of Ordinances, Section 6-1, 8-40, 8-52, 9-1, and 40.00, FBC 105.1, IPMC 304.7, IPMC 304.13.2, IPMC 304.13, and IPMC 304.2 for the property located at 113 West Cedar Street, Tarpon Springs, Florida 34689, and to assess a fine of $100 per day beginning on May 12, 2023 until compliance is achieved and to order the respondent to contact the Code Enforcement Division to arrange for reinspection of the property to verify compliance with the board's order.
I second.
For clarification.
Call, please, excuse me.
All right.
Roll call, please.
Mr. Rollinston?
Don't we have discussion before this?
So, yes, you do have to open this up for board discussion. Also, too, I just wanted to make clear, so you're finding it in violation, and you're giving them until the 11th to comply. Is that my understanding?
Yes.
And then after the 12th, you would be starting a $100 a day fine.
Right.
Okay.
And point out that the city suggested a $250 a day fine. Any discussion? Roll call, Bobby?
Mr. Rollinston?
Yes.
Mrs. Archer?
No.
Mr. Weeks?
Yes.
Mr. Reffidio?
Aye.
Ms. Wade?
Yes. Would you like to summarize for him?
No, I just do want it to be on the record that the 250 came from our recommended
guidelines.
standard guidelines that we do have.
Can I have clarification, though? Because I know some of the things that may have been cited have been complied with, the permit, and which allows the dumpster. So I don't want the citation to include things that have become in compliance.
So those items that have come into compliance will be addressed when the property is re-inspected following the set compliance date. So anything that is already currently in compliance would not be continuing at that point in time, and only those items that are no longer in compliance would be moving forward after the 11th.
So if I have the permit, the renewed permit and the license, the licensing, the plating of the vehicle.
And the procedure for that is you contact the code board and say, we have met those requirements, and they will come out and re-inspect. And you will be given a copy of this order, which reminds you of those things.
Yeah, and Mr. Landiak has pointed out, with the permit, that the dumpsters give him, because they're construction dumpsters.
We understand.
That he's being cited for, but because they're construction dumpsters and work is being done, that should, I don't think that would be considered.
Anything that's permissible under the permit will
Turn this in.
Will be-
It's too late.
addressed by the building department.
The dumpster and these vehicles are on the case that we just previously heard. They are not related to this case.
Yeah, you can't keep them on neighboring property. It has to be on the property where the permit was issued, right?
Correct.
Okay. All right.
Yes, and the inoperable vehicle is on they're on both properties. So there's one vehicle on his house and the other was on the vacant parcel we just heard.
The next case we're going to hear on your listing is number 11. So we're out of order. If you are,
Madam
Ro-
Chairman, are we not doing case number 3?
we're doing out of order because there are folks here for this other case.
Oh, okay, sorry, thank you.
So the next case we have is number 11, Rosen, Hallen, and Fowd Cazella. If someone is here for that case, if you'll come to the microphone, please. This is case number 22-8000428. 131 North Ring Avenue. If you'd identify yourself, please.
Yes, ma'am. Herb Elliott. I'm an attorney here in Tarpon Springs. My office address is 905 East Martin Luther King in Tarpon Springs.
And your name again?
Herb Elliott.
Elliot, thank you. And you have been retained by these folks to represent this property?
Yes, ma'am.
Thank you.
Number 11.
Yes.
Accused themselves previously are comfortable with this case?
Correct.
Okay, everybody else? Thank you. City will present.
Yes, ma'am, this is a second hearing for an affidavit of noncompliance. The compliance date was on March 16th, 2023, and there has not been compliance. Exhibit 1 is going to be the affidavit of noncompliance. Exhibit 2 is going to be the board order that ordered that date for compliance. Exhibit 3 is a photograph taken on the date that was supposed to be compliance, that there had been no changes. Exhibit 4 is the notice of hearing, certified mail receipt, affidavit of posting. Exhibit 5 is going to be the affidavit of code enforcement, prosecution, and investigative costs that we are asking the board accept. And then Exhibit 6 is going to be a letter from the respondent's attorney. They are actually requesting the board for a rehearing of this case. And there are also 2 people here that would like to speak on behalf of this case as well.
On behalf of the city as well.
Not, they're residents that live next door that would like to speak. They weren't here at the first hearing.
Do you have any questions for her? I'll give you a chance to testify, but we had a little problem last time. Questions are who, what, when, where, why, how.
Yeah, I'm familiar with that. I'd like to reserve my cross-examination for a later time, if I could, later on today,
Okay.
to save some time.
Do you want to present your case?
Thank you. First of all, thank you for allowing the applicants to consult with me about their homestead property. And just to resolve any issues, this is in fact their homestead under the Florida Constitution. There's been some question about whether it's homesteaded or not. We have to distinguish between the homestead exemption, which the city typically uses to determine whether a property is homestead, and that is not the determination of whether a property is homestead or not under the Constitution. It is in fact my client's homestead. You can get the homestead, you cannot get the homestead exemption unless it is your homestead, but the converse is not true. I'm not going to pursue this issue anymore, other than to say that they do qualify under the definition of a constitutional homestead. And they did apply for the homestead exemption for next year, but just because they didn't get it yet for this year doesn't mean it's not their homestead. So if I could move on.
Okay, we just object to the relevancy. This is an affidavit of noncompliance. The only thing that in the city's position should be heard is to why they are not in compliance and what reasoning they have for this board not to accept the affidavit.
If I may proceed. I think the board has probably heard enough. I would prefer to get to the remedies to cure this violation. It's not right for someone to cause any drainage problems on a neighbor, however slight. And I have been involved with the City of Tarpon Springs Code Enforcement Board since the beginning, and the board has always been primarily concerned with the end goal to fix the problem. You have done so and continue to do so, if I may say, and done an excellent job, and my compliments to you. So I will defer getting into the facts and the law for the time being, and the rehearing as well, and suggest a solution to the problem and get my clients in compliance. I met a couple of weeks ago with the civil engineers who designed this project on site and found them to be very well qualified and very well versed on the issues and solutions to this problem. As a little coincidence, one of the engineers, her name was Pat Montecchi, her last name rang a bell with me, and it turned out her father, Carl Montecchi, was the principal designer of our sewer plant across the street some 40 years ago. We worked together when I was city attorney at that time, and they'd done a very fine job. Just a little passing inference might be of some benefit to the city. At any rate, before you is a plan to correct the problem. And if I could have Dr. Kazali to present you with some documents, please.
We need to decide whether to accept those in
Yeah.
or not. Has the city been,
Have you gotten a copy?
has the city seen these documents?
Hold
Hold
the
up.
bus.
Hold
The
up, sir.
bus.
Has the city seen these documents?
No, ma'am.
Okay.
Could you please provide a copy to the
I
city?
need to have the
Is
city,
the city objecting to these? Okay. So just wait until Mr. Salzman says whether or not he's objecting to entering these into evidence, please, sir. Thank you.
Well, I understand Mr. Elliott's position. Again, it's the city's position, this affidavit of noncompliance. I understand that there is some potential compliance that Mr. Elliott believes his client can reach. However, again, we're here on whether to accept an affidavit of compliance or noncompliance. I think the only question would be whether or not this board wants to extend the time period or accept the affidavit of noncompliance currently. This is relitigating the case, and I don't believe it's appropriate, so we would object for that purpose.
May I be heard?
Hold on, just 1 second. You entered the affidavit of noncompliance into evidence, correct, as part of your presentation?
Yes, ma'am.
Okay. And is that to all of the charges from the original case, or?
Yes, ma'am.
Okay. Just wanted that to be clear for the record.
so we are declining to enter this new evidence. That's not what we're here to do at this time today. Our charge is to
Still in non-compliance.
accept the affidavit of noncompliance. That's the
May I be
limit of
heard?
our
Mr.,
duties.
do you have any questions for the city staff regarding their
No,
original
I'll agree the
presentation?
property is in non-compliance.
Well,
Now we're
that's,
trying to get the solution to the problem, was what I was saying before. And what I'd like to do is recommend some solutions to this problem before this board, if possible.
Madam Chair, may I state something on behalf of the city? Just to remind the board that we did hear this for almost 2 hours.
Yes.
Our principal planner has done extensive work on this, and the only solution that the city is willing to take for compliance is removal of the pavers completely and putting it back to where it was. That is the only way for compliance on this case.
And that's where I would disagree, and that's what I'm trying to get to.
We understand.
Wasn't
We
there
remember.
somebody else who was wanting to be heard on this case?
Yes.
Wasn't there somebody else here who wanted to be heard on this case?
Yes.
so we kind of got a little far afield from the way that the hearing is supposed to proceed. The city presented their testimony and evidence regarding whether the property is currently in compliance, stating that it's not. So now I'd like to bring it back in to where we were supposed to be, to whether or not you have any questions regarding the city's evidence, and then if not, if you would like to present evidence regarding whether or not the property is in compliance.
We're not here to see other solutions at
Right.
this time.
It is in the discretion of the city officials who are charged with that particular aspect of the code to make that determination. If you have evidence that the property is otherwise in compliance, you can present that.
No, I'll agree that the property is not in compliance, but
So it's
There's
full
no
stop.
but
The
after
property's
that.
not in
you're
compliance.
not going to get involved in solutions.
No, this is not the venue for that. Right now, we're determining whether or not is the property in compliance, yes or no? The hard-cut answer is, no, it's not in compliance. You even said it too. So we're not here to determine how to fix it. That's beyond this board right here.
Okay, let me get to my cross-examination that I reserved before that. I know your first name is Sherry, is that right? Cindy? Cindy.
City.
Okay. You have the documents I supplied to the board. There's a picture of a property at 145 North Ring.
145 North Ring?
Yes.
We have
it's a few-
131.
I know, it's a few doors down. Now, I'll get to the reason for this in a minute if I could. You see that?
I do.
Has that property been cited?
I am not aware of this.
To your knowledge, it's not been cited.
No, I'm not aware of this.
Okay, thank you. That's all I have for this witness.
What point do the other folks get to speak, or do they not?
So he just finished questioning her. Now it is his opportunity to present witnesses and evidence
Right.
regarding whether or not it's in compliance. So
He
if he
just
has
said it
any
was not.
witnesses,
Not
if he
in
has
compliance.
witnesses.
So
So
now, if I-
here's where we are. We're looking to determine whether or not you're going to impose the fine for failure to be in compliance by the date that was set. When you determine the fine amount, the code provides that you are to consider 3 factors: the gravity of the violation, any actions by the violator to correct the violation, and any previous violations committed by the violator. Those are the 3 criteria that you use to evaluate how much of a fine you can impose. Pursuant to your code and state law, on a first-time violation, the most amount of the of a fine that you can impose is $250 per day on a first-time violation, per violation, okay? The city is requesting lower than the highest fine amount, which is $150. So right now, it would be permissible for him to present evidence that goes to these 3 factors, which again are the gravity of the violation, actions taken by the violator to correct the violation, and any previous violations committed by the violator. So that gives you a range from $0 per day to $250 per day that need to be supported by those 3 criteria that I just read. Okay?
Okay, may I be heard? We have a constitutional provision of equal protection. We have a property a few doors down, very much the same situation, has not been cited.
This is
So my
irrelevant.
suggestion to the
Irrelevant.
board,
I'm sorry,
when
sir.
it comes to removing the pavers,
We're not here
it
We have
not be...
we have no evidence
thank you.
of the other
All right,
property.
there's still a request pending for a rehearing of the violation, and I reserved ruling on that. So we have a motion for a rehearing pending from the prior attorney. Could you have a decision on that, please?
A motion for rehearing?
Well, okay, we need to resolve this issue first.
Right.
Right.
Yeah.
Okay.
So I would move forward with,
Need a motion from the board.
Are we going to hear from
What
these
did you
other
have?
residents?
Do you want to, is it appropriate for them to speak yet?
he
Because they
he can
attest
provide-
to the damages it has caused them.
Correct. So they can present evidence as to those 3 factors, and then the city attorney can cross-examine them.
Already. If you'd, Mr. Elliott, if you'd step aside, thank you so much. I understand that you are an affected party. If you'd like to identify yourself and add a little testimony, we'd appreciate that.
When you come to the podium, please state your name, your address, and indicate whether or not you have been sworn. If you have not been sworn, please receive the oath.
Yes, I have been sworn. My name is Roger Green. I live at 133 North Ring, Tarpon Springs, and I am the neighbor of Mr. Fred. And we lived there for approximately a year, went through the wet season, never had any flooding, no issues. When I bought this property, it had proper fall away from my structure. The water was being directed away from my property. When I came back from being out of town in October, I came back, and all along the side of my garage was pavers. And I'm a general engineering contractor. That's what I do for my living. And as soon as I walked up, I seen that all the elevations had been changed, and all the slope was going from Fred's partial all the way up, touching my footings. I complained to Fred. I complained to the contractor that's unlicensed. I said, this is not right. They said, well, we're going to change it. We're going to rectify it. So after a month or so, they finally came back in and they finished the rest of the pavers. I came in and it's even worse because they built it up. The drainage goes around the side of my house. Now it's built up where it can't drain. It created a dam. So now the water is flooding on the back side of my garage. The water that's on the other side of the garage is all coming down, being directed all into my garage. When I noticed that we'd had flooding in the garage because I could see where water had washed underneath my garage prior to the main event rain that we had, and it flooded my garage. This next one, the big storm that came through, and I'm not quite sure of the date that it was, but that rain came through, and the little drains and all the drainage she had was overwhelmed. Nothing was draining. The water was all being directed to my house. I went into the garage. Water was flowing under my floor. I'm having to remove stuff and put it on boxes and trying to preserve everything. And then once the rain subsided, then I had the task of drying and cleaning everything. I had a brand-new fan, a ceiling fan that was damaged because it was in the rain, it got wet. And my biggest concern is this has been going on since October. This has been extended in December. Fred said that he had to have more time because it's Christmas time and he couldn't get it done. And it's just been going on and going on. And here we are now. It started in October and all the way to today. Now they're asking for another extension. This is absurd. It's not fair. My property values have plummeted because of the fact that now that I have to disclose that my property has been flooded. And if it's not resolved, the issues, it's going to flood again. And how can I sell a property and not sign saying that it's not going to flood again? And so I feel like this is wrong, and I apologize to vent on you, and I just feel like I need to express my concerns, and thank you for taking the time to listen to me, because I know it's probably irrelevant to what is actually taking place, because I know they're not in compliant, and I told them at the very beginning that they can do no more than 100 square feet, and they're way over 100 square feet. And I wouldn't even have as much of a problem with it as if they hadn't have directed all the water to my structure. I don't know what the codes are here in Florida, but in California, you have to have 2% away from your footings for at least 10 feet. I'd be happy if I just had 1% for 5 feet away from my property, so that at least I'm ensured that I wouldn't flood again.
Thank you.
Okay, thank you for your time. I appreciate it.
Anybody have a question or like to make a motion?
Well, I don't know if the city had any questions for the witness. Okay. Close the public hearing for deliberations and a motion.
I'm hoping for a motion, yes.
Okay, I move in case number 22-800 000428 to find the respondents, Roseanne E. Halun and Faoud Kazala, as a repeat violator in violation of the City of Tarpon Code.
Aren't we just
No, I don't
accepting, we're
think
just
they're repeat.
accepting
Just
the
repeat.
affidavit
As
of
in-
non-
Okay,
Affidavit of noncompliance.
okay. But the compliance date was 16 March. Okay, they're not compliant. Okay, I move in case number, belay that, move in case number 22-8000428 to find the respondents, Roseanne E. Halun and Faoud Kazila, did not correct the violations on or before 16 March 2023 for the property located at 131 North Ring Avenue, Tarpon Springs, Florida 34689, and to accept the affidavit of noncompliance.
Do I hear a second? Roll call, please, Bobby.
Mr. Ogle?
Yes.
Dr. Matea?
No.
Mr. Rollinston?
Yes.
Mrs. Archer?
Yes.
Mr. Weeks?
Yes.
Mr. Reffidio?
Aye.
Ms. Wade?
Yes. Now, in summation, if this is brought back before us, it's a repeat violator?
Yes, ma'am.
So do you want to explain to them what they need to do?
The property has been found still not to be in compliance. A fine has been imposed retroactive to March 16th, 2023, the date that was set for compliance, and a lien will be recorded on this property. On the date that you do bring the property into compliance, you may call and request a reinspection from the city.
Question?
Yes, sir.
The board granted a continuance until today. How could it be retroactive to last month if we had a hearing today? I would request that the period of compliance be at least a couple of weeks from now for my client to remove papers in question that we think are in violation.
There was already a hearing on this violation, and an order was entered that gave them until March 16th. So there was already an order entered on this case that set the compliance date. Then when it was re-inspected, it was no longer in compliance. It was still not in compliance.
On March 9th, there was a hearing before the board here, and it was continued till today. That's where my confusion comes in.
I don't think so.
That's why I'm here now, because you gave us a
Have
month.
that order, could we pull it
I
up?
do, it's in your packet, it's Exhibit 2. The original hearing date was February 14th, 2023, to which you gave him an extension to come into compliance until March 16th.
My name is Fred Cazalla, 131 North Ring Avenue. At last month's hearing, the city attorney...
Excuse me, sir.
Yes,
You have
ma'am.
not been recognized by this board to speak? Are you going to
Have you
speak, or is your attorney going to speak?
I'd like to make a
Hang on.
statement on behalf...
Hang on. You have not been said your name, your address. Your attorney was speaking for you, and now you've stepped in front of him. Would you please state your name
Yes, ma'am. My name is Fred Cazalla.
and your address?
I live at 131 North Ring Avenue.
And have you been sworn?
Yes, ma'am, I have.
And
Thank you very much.
I'm not sure why he gets
The
to speak. 'cause we
statement that I
closed
would
the
like to
public
make is,
comment.
at last month's Code Enforcement Board hearing, Attorney Salzman stated that the case would be placed on status for today's hearing, and at that time, we would work together with the city to obtain compliance. And I want to state for the record that with that statement being made, we reached out directly to the city to determine what would be required to obtain compliance. At no point did the city work with us, as was stated by Attorney Salzman. We submitted documentation, we submitted emails, we submitted reports. So we're here today to resolve this, to come into compliance. However, we were never given that opportunity, and that's what was heard at last month's hearing before the board.
You were told specifically what to do, and it was to remove the pavers,
Supposed to be
and
in
you've
compliance.
chosen not to
Okay.
do that.
Okay, that's done.
Regarding last hearing, they did request a rehearing. It was before the board last month. However, we extended the request for hearing only to this month because their attorney had stated they were going to come into compliance. Any kind of communication we have had from their attorney was only the request for a rehearing, which is on this agenda. So they do have a request for a rehearing.
My attorney reached out to the city several times to come into compliance.
Okay.
However, we were not given that opportunity.
That is an incorrect statement. That is not true, and I don't know how you can testify on behalf of your attorney. But we made it very clear
He needs
that
to
to come
talk
in
in the mic.
compliance, you need to remove the
The
pavers.
mic.
At last month's meeting, you made the statement. If you want to check the...
Sir, you're
All
out
right,
of order.
okay.
You told us that you were going to come in compliance and remove the pavers.
All right, this hearing is over as to the compliance. The board has already voted that it is out of compliance, and they have imposed the fine to 3/16. Last month's hearing was on 3/9, which was still prior to the date that was in the original order. There was nothing that happened at the last hearing that abrogated the original order of the board, which set a compliance date of 3/16. Now, having the hearing on 3/9 as to whether the property was in compliance would not give them the full benefit of the original order, which set a compliance date of 3/16. So it was continued to this hearing along with the rehearing request, and it was still found not to be in compliance based on the evidence that was just presented and the statements and testimony of both the respondent and the city. All right,
This gentleman shouldn't be talking anymore.
that's it. This case is over. Let's
you.
move on.
Case number 13. Sir, you're going to have to wave the microphone. Thank you. We have folks here for case 13, so we're going to hear that one next. Case number 23-800000019, Palms of Tarpon Springs, the Condo Association at 600 Haven Place. Is someone here for that? We understand we have an attorney and someone else.
To this fine board. Once again, Robert Todd on
Speak
behalf
right
of...
into the microphone, thank you.
I'll eat it if I can. Robert Todd on behalf of Palms of Tarpon Springs, and I have here with me, already sworn in,
Rachel Spangler, I'm the President, Board of Directors of Tarpon Springs Condominium Association.
This is going to be a follow-up hearing, a second hearing for an affidavit of compliance. The board gave two different orders when you heard this last time. One order was to make sure that the property was boarded up securely and have the building inspector inspect it. That is what we are hearing today. They have done that. The photos are in here. Exhibit 1 would be the affidavit of compliance to that section of the order only. Exhibit 2 is the order that was issued by the board. And Exhibit 3 is going to be the photographs that were taken by the building inspector. Exhibit 4 is going to be some emails that went back and forth between myself and the HOA president, advising them that they are in compliance and that they requested the re-inspection. So we're here today only for this one part of the order. The second part of the order will be on next month's hearing.
I don't see why you have any questions or any further testimony. She gave an affidavit of compliance.
Certainly. My understanding on the bifurcation of the issue remains that there were two items, one being a safety concern, which the association was given the minimum time frame to comply with, which the affidavit of compliance is to be entered today, and I don't have any questions or concerns regarding that. The code enforcement case, I understand, is not a separate numbered case. I would like to update the board as to the association's full compliance with regards to the second issue, as well with the hopes of avoiding the necessity for a separate hearing related to an affidavit of compliance next month, or at the very least to avoid the incurrence of fines in the event that between then and now an inspection doesn't timely occur, because I believe today is our last day for compliance on that second bifurcated issue.
And you have applied for her to come out? Have you sent her the request, if you've complied for her to?
I'd be happy to submit documentation to this effect, but if we may, Regina.
So you're going to miss by one day?
Well, if we may, I'd love to get the affidavit of compliance resolved first, and then maybe
Let's take care of
resolve
that.
the
We
rest.
don't even have a case listed for the other.
It's the same case number, same everything
There,
effectively.
it is under the same case number, but there were several things that they had to do under the previous order. So they already have the affidavit as to the one specific issue.
The safety.
Correct, the life, health, safety issue that they've come into compliance with that particular aspect. What they're asking to do is to present evidence of compliance as to the second issue, in the hopes that they don't have to pay essentially to have their attorney return to next month's hearing to present on that second issue.
And
So
have you had time to inspect it or to see this other stuff?
Their date of compliance for the second set of the orders was April 10th, several days ago. They are not in compliance. Per statute 162, I have to give them a 10-day notice for a hearing when they are not in compliance. Due to it only being 3 days ago, that does not give you 10 days, so that's why it has to be on the next board hearing. But as of today, they are not in compliance with that.
Okay. So let's clean up and do the one that we have before us, the affidavit of compliance. Would somebody like to make a motion on that?
I move to, pardon me, I move that case number 23-800000019 be, that the board accept the affidavit of compliance.
Second.
Second, and we can do this by voice vote. All in favor?
Aye.
Aye.
Any opposed? Thank you. Now, I'm unclear, as we only have this one thing in front of us. I understand they want to save money, but there's nothing on our agenda to allow us to
Discuss.
see the next item.
All this is a construction agreement. The board order states that they must apply for the permits. This is dated April 11th, which is still past the compliance date. And as of today, they have not complied with applying for any kind of permits, so this does not prove compliance.
All right, since that was not set today, you know, we'll go ahead and hear evidence as to that, and the criteria from the code at the next month's hearing.
Do that again.
We can hear evidence regarding that and the criteria in the code that I read before. That is what would apply to this. So that's set for next month's hearing, not today.
If I may, Madam Code Enforcement just performed an analysis of the contract and gave an opinion regarding the validity of compliance. If it's not before the code at this point in time, I would ask her to withdraw those comments.
We're not hearing that part of the case, so anyway.
You brought it before the board. We
He needs
just
to
made a
talk in the mic.
clarification.
It's not picking up.
Well, if we seek to address the merits of the contract, we can, but she did that already. So if we'd like to address the
Oh, you
merits.
did it already.
We're happy to do it at next month's meeting, which is
Okay.
what would be our understanding since it wasn't set for today.
Okay. To the extent that we've haven't received a notice yet, would the city be willing to accept submission of the document today as a stipulation related to the association's attempts at compliance at the case that has currently been called? There having been no bifurcation of the case numbers, we are submitting evidence relative to a case number that's currently before the committee.
But we can't rule on attempts at compliance. We can only rule on.
It's
if
a
we did it.
factor under your code that you're supposed to consider.
Okay.
Yes, please. And since we are here on that code issue, I would like to submit that evidence to the board for consideration that at this time, not only have we executed a contract for full remediation of the issue, but that we have, and we can have testimony to this effect, that promises from the contractor for full submission and compliance with the request, which is permit submission. I'd be happy to have that read into the record to show that our attempts to comply, although couple of days late, likely because of the Easter holiday, have been more than fastidious and something that we're working very hard at resolving.
You can accept the evidence if you so choose at this hearing, and reserve ruling for the presentation of, the full presentation of the case at your next hearing if you so choose.
And we do
I'd
not
like to do
object,
that because we've
that's
had
fine.
no time to look at this.
Do you object, Mr.
No,
Salzman?
no, we do not object. That's fine.
Okay.
We don't, I mean, the information has been presented. Any additional information, we have no objection to that. I think, well, I don't want to go into what we'll discuss next month, but we have no objection.
Do you feel like you understand, but don't we need to wait and do it at the next meeting?
Yes.
I
So
don't
you
think
already
we need to
voted.
vote on that.
No, you already voted. Your vote would be to accept, just accept the evidence that he has presented.
And I can do that without a vote. I can
You
accept
can
evidence.
technically.
Is this
Yes.
the only one? The only copy?
We will accept that evidence into the record, and then we'll see you
Next month.
next month.
Thank you, Madam Chairman. I believe we have extra copies. If not, I can
Just
provide
if we have another one, that'd be great, because we want to have one for our packet and then give one.
Can
Or
I
we can
send
just
it-
make copies.
Can I send one to your email, since I have it?
Send it to Cindy.
Cindy's?
Yeah.
Get you both. All right.
Thank you.
Anything further, board?
Unless I'm wrong, there's,
For Palms of Tarpon, that is.
no,
In my excuse, thank you.
are you here for case 9?
She
No,
spoke at
this
the,
is done. This is done. We're done on this.
We
Thank you.
heard from you last time, so thank you. We're pushing them as best we can. Thank you.
Oh, thank you.
Thank you. Are you here for case 9, sir?
he didn't have a packet. I guess he's not here for anything.
Robert Marshall?
Well, I'm just here as a witness. He's not here. I don't know where he is, but I'm going to give whatever information you guys have.
Thank you. Let's go ahead and address that case since we're on 9, and if he's here, sorry, not here. Case number 9 on your agenda, 23-008, 00001, Robert Marshall, 333 Manatee Lane.
Yes, ma'am, we're here for a second hearing on the affidavit of noncompliance. Exhibit 1 is going to be the affidavit of noncompliance. Compliance date was set for February 28th, 2023, and as of today, it is still not in compliance. Exhibit 2 is going to be the board order from February. Exhibit 3 is the notice of hearing, certified mail receipt, and affidavit of posting. And Exhibit 4 is going to be several emails from a neighbor as well as somebody who did rent out as a short-term vacation rental after the date of compliance. Number 5 is also going to be the affidavit of code enforcement, prosecution, and investigative costs that we are seeking approval for. And that is all.
Would anybody like to make a motion? Affidavit of noncompliance.
I move to accept the affidavit of noncompliance.
Second.
And to award the city $146.78.
Is that retroactive to the date set for compliance, which was February
28.
28th?
28.
February
20?
28th, right. Yes, sorry.
Second.
All in favor?
Aye.
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 Any opposed? Thank you. Thank you, sir. That fine was imposed, he was given notice of that. I'm sorry, I can't converse with the audience, but if you contact the code enforcement, her name is C. Stoner, if you want to go by email, or you can call the police department and they'll put you in touch.
This order will be reduced to writing, and it will be delivered to the property owner in accordance with the code. Thank you.
We're skipping 1 and 2, they're not being heard. We're moving to case 3, which is new business. Case number 23-80000033, Stanley Kavoris and Demetrios Kavoris. It's a empty parcel, and the city will present its evidence.
This is not a homesteaded property. On February 16th, 2023, I inspected the property located at parcel number 122715-73674-0000070 due to a citizen complaint. This is a vacant residential property that's not being maintained and has a history of such. There's a large dead tree in the middle of the property that's dropping branches and could be a hazard should it fall on the neighboring properties. There's also a concrete block wall that's in disrepair, cracked, broken, and missing bricks. The property was posted with a notice of violation with a compliance date of March 2nd, 2023. A copy mailed to the property owner via certified mail and posted at Tarpon Springs City Hall. A reinspection was completed on March 2nd, 2023, and found that no efforts had been taken to bring the property into compliance. Several further inspections were also completed on March 13th, 20th, and 29th, and found the same, and no contact has been made from the property owners. Due to noncompliance, the property was referred to the Code Enforcement Board. Compliance can only be achieved by utilizing a licensed contractor with proper permits to remove the dead tree and repair or replace the brick wall. All permits are to be applied for, approved, issued, and finalized. A hearing notice was posted on the property on March 29th, 2023. A copy mailed to the property owner via certified mail and posted at Tarpon Springs City Hall. The division recommends giving the respondent until April 27th, 2023 to achieve compliance. If compliance is not achieved, staff recommends the Code Enforcement Board impose a fine of $125 per day, beginning on April 28th, 2023, until the property is brought into compliance. Exhibit 2 is going to be a photograph of the tree in question, as well as the broken brick wall. Exhibit 3 is going to be the notice of violation, certified mail receipt, The returned mail that it was not picked up from the post office, and the affidavit of posting, the notice of hearing, certified mail receipt, and the affidavit of posting for that. Exhibit 4 is going to be the property appraiser and the tax collector. And that is all.
No one has a question? Perhaps someone would like to make a motion?
Before that, I would just like to put on the record that nobody has appeared for this hearing on behalf of the respondent. Thank you.
Ms. Stoner, can you give us an idea of where this property is located streetwise?
There's a map in here?
Is there a map?
Yes.
It's located over, cross between Hope Street and West Cedar. If you were to go west on West Cedar, right before you get to Hope Street, it's going to be on the right-hand side.
Okay.
The map is Exhibit 4.
She's referring to this one here,
Oh, okay. Gotcha.
back
Thanks.
of the property appraiser's office.
Gotcha. Thank you, ma'am.
You're welcome.
I move in case number 23-8000033 to find the respondents Stanley J. Kavoris and Demetrios P. Kavoris in violations of City of Tarpon Springs Code of Ordinances, Section 133.02 and 9-1 and IPMC 302.7 for the property located at parcel number 12-27-15-7364-000-0070, and to assess a fine of $125 per day beginning on April 28th, 2023 until compliance is achieved, and to order the respondent to contact the Code Enforcement Division to arrange a reinspection of the property and verify compliance with the board's order.
Second.
He spoke
I will-
in giving the number. He missed one number in all those numbers. Do we need to correct that, or we have it printed, so it's okay?
I would just request that the written order reflect the appropriate parcel number as identified in the property appraiser's office.
Thank you.
Thank you.
So
I
a
will
motion has
second.
been made and
Seconded.
seconded.
I second.
And Bobby will call roll.
Mr. Ogle?
Yes.
Dr. Matea?
Yes.
Mr. Rollinston?
Yes.
Mrs. Archer?
Yes.
Yes.
Mr. Perfidio?
Aye.
Ms. Wade?
Yes.
Thank you.
Item number 6. There's no one here for that one either. We'll put it in the record. Case number 23-800000036, Thomas Valerto.
Loretto.
And it's again a empty parcel. And the city will present their evidence.
This is not a homesteaded property. On February 24th, 2023, I inspected the property located at parcel 12-27-15-21078, 0000030 due to self-initiated activity. Upon arrival to the property, it was observed that this is a vacant residential parcel that is very overgrown with grass, weeds, and other vegetation in excess of 12 inches in height. There is also scattered junk, trash, debris, sand piles, and piles of broken fence. Several trailers were also on the property that were not permissible to be stored due to being a vacant parcel. It's unknown if they have valid tag or registration, however, they do have flat tires. The property was posted with a notice of violation with a compliance date of March 13th, 2023, a copy mailed to the property owner via certified mail, and posted at Tarpon Springs City Hall. A reinspection was completed on March 13th, 2023, and found that no efforts had been taken to bring the property into compliance. Several further inspections were also completed on March 20th and 29th and found the same, and no contact had been made from the property owners. Due to noncompliance, the property was referred to the Code Enforcement Board. Compliance can only be achieved by mowing and maintaining the property of all grass, weeds, and other vegetation below 12 inches in height at all times, properly removing all junk, trash, debris, and other items from the property, and removing the trailers. A hearing notice was posted on the property on March 29th, 2023. A copy mailed to the property owner via certified mail and posted at Tarpon Springs City Hall. The division recommends giving the respondent until April 27th, 2023 to achieve compliance. If compliance is not achieved, staff recommends the Code Enforcement Board impose a fine of $75 per day, beginning on April 28th, 2023, until the property is brought into compliance. Exhibit 2 is going to be photographs of the property. You can see all of the overgrowth, the trailers that are there, the broken fence pieces. Exhibit 3 is going to be the notice of violation, the certified mail receipt, the UPS tracking showing that it was delivered, as well as the affidavit of posting, the notice of hearing, certified mail receipt, signature card that it was received, and affidavit of posting. And Exhibit 4 is going to be the Pinellas County Property Appraiser and the tax collector. I did finally hear from the property owner this morning. He has mowed 95% of the property. The trailers are gone. However, there's now a boat there that's not supposed to be there, and the tree debris is still there. I told him that I was going to recommend another 2 weeks at the hearing, and he said he was fine with that, and within 2 weeks he'd have everything done.
He lives right here in town.
Yes. It's over off of by Roosevelt and Hope, that same area.
You did not cite him for the boat, though.
I did not. That just was new today.
And I'm looking at section 8-40, the duty of maintenance, and on the notice of violation here, where it says the remedy is to properly maintain the property so it does not continue to be a nuisance to the citizens of the city. And then the code section states that no person owning, leasing, operating, occupying, or having control of any premises within the city shall maintain, keep, or permit any nuisance as defined in 8-38, and as further defined in 8-34. Can you describe what those are?
The like nuisance conditions is
Correct.
Would be the same thing as like overgrowth, junk, trash, debris, causing any kind of nuisance to a neighbor, a citizen, health hazard, safety issue, things like that.
And how does that relate to this property?
The overgrowth, the junk, trash, debris, the broken wood that's there could be a fire hazard as well.
Okay, thank you.
Yes, sir.
Excuse me.
No, not.
What are the implications of this is not a homestead property?
No, none.
That only matters with respect to the lien. So you can't foreclose on homestead property. So regardless of whether or not it's homestead, the city codes still apply and the maintenance code still applies. There's no exemption from the maintenance codes just because it's not homestead property and somebody may or may not be living there. But if it is homestead property and we place a lien on it, then we cannot foreclose on that lien pursuant to law.
Thank you.
Would anyone like to make a motion if you don't have another question? And this would be a motion for
Finding a violation.
just finding the violation itself.
And also assessing the fines, right?
And giving a date of compliance.
Yeah. I move in case number 23-8000036 to find the respondent Thomas Filaratu in violation of the City of Tarpon Springs Code of Ordinances, Sections 8-40, 8-52, and 40.00 for the property located at parcel number 12-27-15-21078-000-0030, and to assess a fine of $75 per day beginning on April 28, 2023, until compliance is achieved, and to order the respondent to contact the Code Enforcement Division to arrange for reinspection of the property to verify compliance with the board's order.
I'll second.
Seconded?
Second.
Thank you. Roll call, Bobby?
Mr. Ogle?
Yes.
Dr. Matea?
Aye.
Mr. Robinson?
Yes.
Ms. Archer?
Yes.
Mr. Weeks?
Yes.
Mr. Farrugia?
Aye.
And Ms. Wade?
Yes. On your paperwork, the next case is case number 7, 23-800000049, John Santos and Legia Santos. It's again an empty parcel, and the city will present its case.
This is not a homesteaded property. On March 7th, 2023, I inspected the property located at parcel 122715, 47610-000-0440 due to self-initiated activity. Upon arrival to the property, it was observed that this is a vacant residential parcel that is very overgrown with grass, weeds, and other vegetation in excess of 12 inches in height. There is also scattered junk, trash debris, and tree debris. The property also has Brazilian pepper trees as well as dead, dying, and diseased trees that could pose a hazard should they fall on a neighboring property. The property was posted with a notice of violation with a compliance date of March 24th, 2023, a copy mailed to the property owner via certified mail, and posted at Tarpon Springs City Hall. A reinspection was completed on March 24th and found that no efforts had been taken to bring the property into compliance. Another inspection was also completed on March 29th and found the same, and no contact has been made from the property owners. Due to noncompliance, the property was referred to the Code Enforcement Board. Compliance can only be achieved by mowing and maintaining the property of all grass, weeds, and other vegetation below 12 inches in height at all times, properly removing all junk, trash, debris from the property, and with the use of a licensed contractor and proper permits, remove the Brazilian pepper trees and dead, dying, and diseased trees. All permits are to be applied for, approved, issued, and finalized. A hearing notice was posted on the property on March 29th, 2023, a copy mailed to the property owner via certified mail, and posted at Tarpon Springs City Hall. The division recommends giving the respondent until April 27th, 2023 to achieve compliance. If compliance is not achieved, staff recommends the Code Enforcement Board impose a fine of $75 per day beginning on April 28th, 2023 until the property is brought into compliance. And Exhibit 2 is going to be pictures of the parcel. It is nestled right inside of a little residential street, so it's overgrowing on both of the properties on each side. Exhibit 3 is going to be the notice of violation, the certified mail receipt, and the affidavit of posting. The notice of hearing, certified mail receipt, and affidavit of posting. And Exhibit 4 is going to be the property appraiser as well as the tax collector. And as of today, I still have not had any contact from the property owners, nor has anything been done on the property. It remains in the same state as it did before.
I had one question. This is going to require a permit,
To remove the trees, it will, yes.
and that can be done in the time that we've given?
It could, yes. Tree permits are generally
You
rather
go in and
quick.
they hand it to you?
Normally, yes.
But is that, you said permits for trees, is that the pepper trees, or is that?
No, you can
Sorry.
take those out.
It's the other large trees in there that are
Okay,
diseased.
thank you.
You're welcome.
Motion? Yes, please.
I move in case number 23-800000049 to find the respondents, John Tessence and Elijah Tessence, in violation of the City of Tarpon Springs Ordinance, Section 8-40, 8-52, and 8-53, 133.02, and 133.03 of the property located in parcel 12-27-15-47610-000-0440, and to assess a fine of $75 a day beginning on April the 28th, 2023, and until compliance is achieved, in order to the respondent to contact, and to order that the respondent contact the Code Enforcement Division to arrange for a reinspection and verify compliance with the board's order.
Second.
Roll call, please.
Mr. Ogle?
Yes.
Yeah?
Aye.
Mr. Rollinston?
Yes.
Mrs. Archer?
Yes.
Mr. Weeks?
Yes.
Mr. Video?
Aye.
Ms. Wade?
Yes. Case number 8, 23-8-00000062, Craig Eric Johnson and Kristen Marie Jarvis Johnson. And the address is 1410 Poinsettia Avenue.
Before we present any evidence in this case, we have received a request to continue this case. The owners of the property, this is a short-term rental case. The owners of the property are out of the country or on vacation from April 5th through April 15th. They did contact us. They said that they were trying to find an attorney to represent them. They were unable to find a local attorney. The one property owner is an attorney, and she could represent them, but since they're out of town, they're unable to do so. It is a short-term rental case. It's not something that, has an impact of debris or some health or safety issue, so we would like the board to at least consider that before we present our case.
My problem with that is we've seen quite a number of these, and they get delayed, and the neighbors still have to put up with a lot of people coming and going that they shouldn't have to put up with.
Just presenting what they sent to us.
Got it.
I have a question. Is it not still the city's position that we don't have short-term rentals?
In certain
In
zones.
certain areas, yeah.
Well, let me put it this way. We believe there's a violation of the short-term rentals in this case. We have received information that was sent by the parties in this case to the city stating that they believe that they're allowed to use it the way they're using it. And they have some legal arguments that they want to either preserve by putting on the record or present to you.
Motion that we defer this case until the next meeting. I'd like to hear those.
Do we have to vote on that?
If there's a second, yes.
Second.
Bobby?
Roll call?
No, if there's no further discussion, you can call the question, Madam Chair.
Are we going to hear the city's
Do we
case?
have to, doesn't she need to call roll? Bobby?
Is that what
We
you're asking
voted.
her to do?
We just voted.
Roll call?
Yes, ma'am. Mr. Ogle?
Yes.
Dr. Matea?
Aye.
Mr. Rollinston?
Yes.
Mrs. Archer?
Yes.
Mr. Weeks?
Yes.
Mr. Video?
No.
Ms. Wade?
No.
Your motion carries.
This case is
Is
deferred to the
deferred.
May 11th Code Enforcement Board hearing.
Next case. Skip down to 10. Case number 22-00000253, Ruth B. Wright, Living Trust, 1500 Sunset Road, Unit F6. This is an affidavit of noncompliance.
Yes, this is a second hearing for affidavit of noncompliance. That would be Exhibit 1 is the affidavit. The date of compliance was to be February 28th, 2023, and as of today, it's still not in compliance. Exhibit 2 is going to be the board's order. Exhibit 3 is the notice of hearing, certified mail receipt, affidavit of posting. Exhibit 4 is going to show that the permit is not finalized as of the date. Exhibit 5 is the affidavit of code enforcement prosecution investigative costs we're seeking approval on. And as of today, the permits have actually been applied for.
Say that again?
The permits have been applied for about a week ago, and they just have to go through the process. So it's going to be a little while before they're done.
So just to clarify, you don't consider, is it when the permits are granted or is it when the permits are applied for that you consider it to be in compliance when they're required to receive a permit?
This one is twofold. She had work without permit, so the permit has to just be issued. But then because so much work was already done, those permits have to be finalized. So this one has issued and finalized permits.
Okay.
This was that little condo unit.
Yes, ma'am.
Yes. So you need from us the affidavit of noncompliance with a fine attached.
In case number 22-800000253, I accept the affidavit of noncompliance and award the city $146.78.
Second.
We can do
I'll
a
second.
voice, we can do a voice vote on this. All in favor?
Aye.
Yes?
Yes.
Any opposed? Skip down to 12 now. Also an affidavit of compliance, case number 22-800000020, Betty Nolan. This is a parcel, so there's no home involved.
This is going to be an affidavit of compliance. That is on Exhibit 1. Exhibit 2 is the board order that ordered compliance by April 11th, 2022. They did come into compliance on March 9th, so there will be fines due on this one. And Exhibit 3 is going to be the notice of hearing, certified mail receipt, the certified card that it was received, as well as, yes, it was received. And then Exhibit 4 is going to be an email from the city stating that the inspection was completing and that the building department was satisfied with it being in compliance.
I'm unclear as to the total fee.
It's going to be.
183 plus 180 plus 25?
Well, it was out of compliance for a total of 332 days at $25 per day. You awarded previous prosecution costs of $180. I'm not sure what the clerk's office charges extra, so that's why I did not give you a final price.
Got your calculator out?
That's what I'm doing.
How many days was it out of compliance?
332.
32, so that's $8,300 for a 25-hour day fine.
I concur.
And this says that the costs, the $180 costs are the costs of prosecution and not administrative costs?
That was the affidavit of prosecution costs that were accepted at the
At the-
hearing
okay.
last year.
Got it, I see that.
Have they
May
been
22.
paid?
No, nothing's been paid, but that's why I can't give you a total, because I don't know what the clerk's administration fees are that would be added on.
So
So-
how can we,
That's what I was just gonna say.
Okay.
We can't do that unless you present evidence of what the fees
Total.
are. So they can rule on this now, or you can bring it back with an affidavit of what those fees would be.
They-
We'll accept ruling on it now, and we'll waive those other fees.
You're gonna wait, the city will waive the other fees? Okay.
wait,
He requested to waive those fees.
Okay,
The clerk's
so-
fees, so just
okay.
what the fine is.
so,
So no prosecution costs?
No, the prosecution costs are the 180.
Yeah.
Okay.
But nothing additional to that besides the amount of the fine.
so we're looking at 8480 is is the total, 8,480. Prosecution cost plus $8,300 in daily fines. Right?
Yes.
Okay.
Your daily thing?
What's that?
When you did the
It
calculation?
was $8,300.
And then we added 180 to that.
Yeah, it gives us
Got it.
8480.
Would you like to make a motion to that effect, sir?
Okay. I move in case number 22-8000020 to find the respondent, Betty Nolan, did correct the violations, but did not pay the fine of $8,480, and to accept the affidavit of compliance.
I'm sorry, what was that total?
$8,480.
Thank you.
Is my math correct, I hope?
Yes.
Okay.
$8,275.
I'll second.
Thank you.
Purpose of discussion.
It's a significant amount. Let's do a voice, or do a actual roll call. Are we getting you confused, Bobby?
No, ma'am.
We're
No,
good?
Not at all.
Okay.
You want a roll call?
But
Yes.
I would like to do a
That-
roll call on it.
Yes, that's fine. Mr. Ogle,
Yes.
Dr. McKaya,
Aye.
Mr. Rollinston,
Yes.
Mrs. Archer,
Yes.
Mr. Weeks,
Yes.
Mr. Fafidio,
Aye.
and Ms. Wade.
Yes.
That completes your roll call.
And we can clump 14, 15, 16.
No fines.
We're going to hear items 14, 15, 16, 17, 18, and 19 all together. I'll read the case numbers, but there are no fines associated with these, and so we can do them as a lump sum. Case number 14 is item 22-8000371, Gulf Marine Ways Incorporated. These are all in compliance. Case 15, 22-800000349, Jana Dudova and Samuel Ellis Pace, that's 807 River Lane, is now in compliance. Case number 16, 22-800000346, Salvatore Minash at 900 Riverside Drive, is in compliance. Case 17, number 22-800000408, Palm Springs Estates, lot number 44, is in compliance. Case 18, which is 23-800000009, KPM of Tarpon LLC, at 38954 US Highway 19 is in compliance. Case 19, number 23-800000016, Sherry Went on 109 Hibiscus Street. All of these are in compliance, and we will address them by a voice vote. All in favor?
Aye.
Any
Sorry,
opposed?
There wasn't a motion.
Okay, I make a motion that you that these above referenced case numbers are in compliance.
Second? Anybody?
A second.
Thank you. All in favor?
Aye.
Any opposed?
Just to clarify that you are accepting the affidavit of compliance?
Yes.
That's correct.
Thank you.
That's the end of our agenda. I did want to put on the record, and Steve, if you'll pass this along, Officer Boone was so kind to one of our citizens last time who was quite upset about a case, and I wanted it on the record how kind he was to her and the comfort that he provided her. Please pass that along to him. Thank you.
Madam Chair, before you adjourn, I do have a quick question. When you take the cases out of order, do you have a sign-up sheet or some other mechanism of knowing who's here for these cases?
The city gave me that information today.
I informed her of which cases had attorneys here first.
Okay. Currently, it's not in your rules of procedure to do that. And we can change that, and you do have, you know, as the chairwoman, the ability to do that. But then it gets confusing for, I think, both the board members and the people in the audience by continuing to take the cases out of order like that. So what my preference would be is that if you have a sign-up sheet for, you know, to identify who's here, and then you can provide that to the chairwoman, so that, you know, she has a written document that says which cases have people here, and then you can go down and take those in order, and then go back and take the ones that, where there's nobody here, but still maintaining the order that they're set out in the agenda.
Absolutely, that would be my error then, because I told her
Didn't we
before
do
started.
that?
I couldn't really follow how, I feel like, you know, we took like the ones, we took 13, then we took like 4, and I just
I
wasn't
took the ones
clear.
with attorneys first, so it
Right.
wouldn't cost them so much money.
And that's fine, I understand that, I just want to make sure that we have, you know, a method that we're
Consistent.
using that's fair for everybody.
We'll do that moving forward.
Okay,
Yeah,
thank
so
you.
how do we amend our procedures? Do we
We're
have to do-
we're already planning on coming
Okay.
back to you with some of that we're
Yeah, you don't need
working
to
on,
worry
and we
about
can include
for-
that.
We'll just have that in place
Right,
until you
okay.
adopt something.
Okay, super.
Did you feel like everybody was fairly heard?
That's not really for me to determine.
That's what we always want to do.
That is the goal.
The city feels like it was heard.
Thank you. Anybody else have any other motions, comments? I'll miss you guys next time. And our most competent vice chair will take over, and the meeting's adjourned.
Go easy on me.
Okay, you probably want...